Hello guys, welcome back to a new topic. So friends, today in this short video, I'm going to share with you all about the writ, as to what is the meaning of writ petition, where is to be filed, what are the kinds of writs, writ of habeas corpus, mandamus, certiorari, quo warranto, and how to file it before the court. So firstly, we see what is writ. A writ is a direction issued by the court which is to be obeyed by the person or authority to whom it is issued. The Supreme Court of India may issue a writ under Article 32 of the Constitution for enforcement of fundamental rights of the citizen, and under Article 139 enforcement of rights other than the fundamental rights. High Court in the states may issue writ under Article 226 of the Constitution of India. So what is the writ petition? Writ petition means a petition seeking issuance of a writ. Because writ petitions in the first instance in the High Court and the Supreme Courts are the writ petitions. So what are the types of writs? There are basically 5 kinds of writs, like habeas corpus, mandamus, certiorari, prohibition, and quo warranto. I want to explain it in a very short points. I have already made a separate videos on regarding on each and every kinds of writ. You can check it from the playlist. And firstly, here I am only telling you about only the main points of these 5 kinds of writ, because it is a short video for examination purpose where you may know about what is the writ, what are its kinds, and what are its general meanings. So firstly, a writ of habeas corpus is issued to an authority or a person to produce in a court a person who is either missing or kept in illegal custody. Because where the detention is found to be without authority of law, the court may order compensation to the person to illegally detained or to release it from the illegal detention. So now what is the writ of mandamus? Writ of mandamus is a direction to an authority to either do or refrain from doing a particular act. For instance, a writ to the police department to strictly enforce traffic rules under the acts, and for a mandamus to be issued, it must be shown that the authority was under an obligation, statutory or otherwise, to act in a particular manner, that the said authority failed in performing such obligation, and the such failure has resulted in some specific violation of a fundamental right of either the petitioner or an indeterminate class of person. So now what is the writ of certiorari? A writ of certiorari is a direction to an authority to produce before the court the records on the basis of which a decision under challenge in the writ petition has been taken. By looking into those records, the court will examine whether the authority applied its mind to the relevant materials before it took the decision. If the court finds that no reasonable person could come to the decision in question, then it will set aside that decision and give a further direction to the authority to consider the matter afresh. For example, the permission given by an authority to operate a factory next to a hospital can be challenged by filing a petition asking for a writ of certiorari. Second writ is next writ is what is a writ of prohibition. A writ of prohibition issues to prevent a judicial authority subordinate to the High Court from exercising jurisdiction over a matter pending before it, and this could be on the ground that the authority lacks jurisdiction, and further that prejudice would be caused if the authority proceeds to decide the matter. Where the authority is found to be biased and refuses to rescue, a writ of prohibition may lie. Last writ is quo warranto. In this case, a petition seeking a writ of quo warranto questions the legal basis and authority of a person appointed to public office. For instance, the appointment of a member of a railway board not qualified to hold the post can be questioned by a writ of quo warranto, and the appointment nullified if it is found to be illegal. A writ of declaration issues to declare an executive, legislative, or quasi-judicial act to be invalid in law. For example, a court could declare Section 81 of the Mental Health Act 1987 that permits use of mentally ill patients for experimentation to be violative of the fundamental rights of the mentally ill and therefore illegal and void. A petition seeking such declaratory relief must also necessarily seek certain consequential relief, for example, immediate discontinuance of the illegal practice and approach medical compensation. These apart, a writ petition could seek other writs like orders and directions which the court may fashion in response to the facts placed before it. Now, how to file a writ petition? A writ petition can be filed in the Supreme Court of India under Article 32 or the High Court of the States under Article 226 of the Indian Constitution through a counsel and or himself or herself in person according to the type of writs. So basically format of writ petition is available in the website, or we can also share with you if you need. If you mention to us, I will provide you the format of all the 5 kinds of writ, because first of all the type of writ should be desired as to what the needs and requirements are to be incorporated in it as per the desire and facts of the aggrieved party. So friends, I hope you like this video, and in case of any query you may mention, I will definitely give response there too. Thanks for watching this topic.